Well, I believe we're live. Hi, everyone. Welcome to DeFi and the Law, presented by The Block Crypto. My name's Steve Palley. I'm a partner in the Washington, D.C. office of Anderson Kill, and I chair the firm's technology, media, and distributed systems practice, which includes blockchain and crypto, using those terms somewhat loosely. And I'll be moderating this panel of really fantastic lawyers, folks who have fantastic, deep experience as lawyers in their field. That is to say, they went to law school and learned how to practice law, but also focus specifically on crypto. And I think if you follow people on Twitter, you may have the misimpression that everyone on Twitter who's talking about law actually practices law, but these folks are all really, really deep and impressive practitioners, each one of them. And there's certainly others out there. Unfortunately, we only had space for 6 folks on this screen. We've got a great outline for discussion today. You can ask questions if you like. We'll try and answer them on the fly. Our plan is to level set by talking about technology, talking about law, and then just getting right into some of the most pressing cutting edge legal issues that we're seeing in the DeFi space today. Now, I've introduced myself, but before we get going, and begin with level setting, I would really love to hear from my fellow panelists. And as opposed to me trying to mangle their biographies, I'm going to let each of my colleagues introduce themselves. Let's start with Sarah. Go ahead.
Thank you. Thanks. Yeah. So I'm Sarah Shtylman, and my legal career began, I suppose, when I started law school, which was fall of 2008. And so really my entire legal career has been shaped by what happens when there's a lack of transparency and or understanding in our financial system. And I went to law school with the dream of going in-house someday. I really wanted to work with businesses. And so the kind of convergence of that began in 2013 when I started really digging deep into Bitcoin. And I thought, this is so interesting. This is a protocol that can add a lot of transparency and visibility into the financial system and into people understanding what happens with their own money and kind of having control of that. And that led me in-house to Coinbase, where I worked for a couple of years on all of their money transmitter and a lot of compliance with various FinCEN regulations and related commercial agreements. This was the early days, so it was a little bit of everything. And ultimately, the reason I decided to leave was because there was so much else that was happening in the broader crypto space that after a couple of years, I realized I don't actually want to pick just one client. And so I sort of took a deep breath and thought, all right, I'll give billable hours another try. And I joined Perkins Coie, largely because they already had an established virtual currency practice. And so there were a handful of folks, Dax Hansen, Lowell Ness, Joe Cutler, folks who were already working in the space. And I thought, well, I might not get to spend 100% of my time on crypto, but at least I'm with other folks who find this space interesting and want to dig deeper. And it really does sometimes add up to 100% of my time. But still working on a lot of the virtual currency related issues that come up with money transmission, FinCEN, and I'll leave it at that.
That's cool. So you really got to see how the sausage was made at Coinbase
right.
Early days. That's so cool. And Sarah's going to be talking to us a little bit later, specifically about FinCEN and OFAC and the application of the regulations that they administer and enforce to DeFi, to the DeFi and crypto space in particular. Gabe, let's go ahead and have you tell us about yourself, who you are, where you practice, what you do.
Hey, my name is Gabriel Shapiro. I'm a partner at a California boutique called Belcher, Smolen, Van Loo, and primarily a corporate and securities attorney by training. Worked at a lot of the big firms, primarily doing buy-side tech M&A for the likes of Facebook and Oracle and big evil companies that everyone hates now. Yeah, actually, as part of that, I did like the Facebook WhatsApp deal, and a lot of that was about end-to-end encryption and that sort of thing. And
cool.
that sort of ended up being my avenue into crypto, and I got more and more interested in crypto. And then in 2018, I, pretty much quit my big law gig to do it full time, and I've been doing it since then.
Lewis, and actually, you guys, Gabe and Lewis, you guys worked together for a while, didn't you?
Yes, we overlapped
We
at
worked together
Hogan Lovells
twice.
for a while. That's right.
Yeah.
Oh,
Two
well,
times.
and yes, and
Yes.
at Lewis's firm. That's right.
Yeah, that's a pretty small bar still. So, Lewis,
Yes.
go ahead, please introduce yourself. Tell us about your practice, your experience, which is very, very interesting and very deep.
Sure, Stephen. So thanks for having me. Lewis Cohen, I'm a co-founder of DLX Law, and I had a long career. I prefer not to count the exact number of years in big law, doing kind of traditional finance, particularly capital markets, a lot of structured finance, a lot of working with the main regulators, particularly the SEC, also CFTC and others, on behalf of large Wall Street organizations and the people that they love. And in May of 2018, I kind of thought, if we're going to do this, there's only one way to really do it. And we started our own firm with my co-founder, Angela Wilson. And we were shortly joined by a number of others, including Gabe for a time, which was fantastic. And we do pretty much most things in the blockchain and crypto space, but with a particular focus on regulatory issues, capital markets, commodities, bank secrecy, and things like the Wyoming SPDI and related things. And we have a lot of fun with it. So thank you.
So I've already introduced myself, so I'll spare you further. Ryne, why don't you tell us about yourself and your practice? You were with I understand you were with the CFTC for a while. Is that right?
Yeah, thanks, Stephen. So I'm Ryne Miller. I'm a partner at Sullivan and Cromwell in New York. I started at the CFTC 2010 to 2013, largely grew up there doing Dodd-Frank implementation, Dodd-Frank rule writing for the swaps market. Has nothing to do with the U.S. derivatives market yet in terms of crypto, but someday. I came to Sullivan and Cromwell to work on the commodities, futures, and derivatives team. That practice was largely focused and continues to be focused on trading businesses, hedge funds, buy side, trading businesses at banks. And so when crypto and particularly Bitcoin became a traded asset class by the prop firms, I think that's where it started, and it starts to spread. Clients started showing up and saying, can we trade this? How do we trade this? Are there assets besides Bitcoin that we can trade? And that all started to come together, 2014, 2015, 2016 as a practice. And as the industry and the ecosystem grew, and the experts here will describe what all of that means in much better words than I can, even the traditional financial institutions clients started asking, what is this space? And what does the CFTC think? What does the SEC think? Where is FinCEN? And so as all of that started to grow out of little inquiries from our traditional clients, we also started to get some infrastructure clients as well. So exchanges, startup exchanges, existing exchanges, and I think that's been the basis of my crypto work so far. And happy to be here with this group today.
Thanks so much. And last but most, I think I coined that.
That was good. I'll take it.
Good. Rebecca, tell us about yourself and your practice. You recently changed law firms too, if I
I
recall correctly.
did. So my name is Rebecca Rettig. I'm a partner at Manatt, Phelps, and Phillips in their financial services group. My practice mostly focuses on blockchain and crypto. I started my career at a firm in New York called Cravath, Swaine & Moore, where I did a lot of heavy securities litigation, but also sort of risk mitigation and some enforcement work as well. And then about 4 years ago, I read some articles early back in 2012, 2013 about Bitcoin and Mt. Gox and just was generally interested. But about 4 years ago, I left and really started practicing heavily in, to start at least, crypto and blockchain related litigation. I did a very, very early private arbitration, multi-parties with a bunch of traders and exchanges. And that's really where my career started. And then sort of took off from there. I felt like once you're in the space back then, everybody just sort of comes out of the woodwork. So I would say the majority of my practice is blockchain and crypto related. Some disputes, blockchain hacks, certainly regulatory investigations and subpoenas. And for the past 18 months, I've been focusing really heavily on DeFi and talking to different projects and doing a lot of regulatory counseling.
Cool. Well, I want to begin. Thanks everyone for the introductions and for telling us about your experience, which definitely informs the conversation. I think it'd be useful to begin by sort of level setting and maybe providing some definition to the term DeFi. I think everybody knows what Bitcoin is at this point. We've been through a couple of phases or inflection points in crypto, as it were already. It's almost like 100 years in 10. And I see several different inflection points, maybe 2011, 2014, 2017, the most recent, the ICO token craze, and we're seeing that litigation tail now. And DeFi, I think as a term, is something that we first started to see maybe a year and a half or 2 years ago, getting more prominence. But I want to talk about, what does it mean? What are we talking about when we talk about DeFi? And then we can talk about its significance or its place in the legal frameworks in which we work. So Gabe, you're a pretty technically minded guy, and I've read a bunch of your securities analysis of DeFi projects. I'd love it if you could start by giving us sort of a down and dirty, maybe slightly technical explanation of your understanding of what DeFi means. Give us some definition.
Sure. So first of all, to state perhaps the obvious, DeFi stands for decentralized finance, right?
Oh, I want to actually say something
Sure.
Before I cut you off, actually.
Yeah.
The opinions that we're expressing here are our opinions only. They do not reflect the opinions of our clients, past, present, or future, our law firms. We might change our minds. We contain multitudes. Go ahead.
A very good disclaimer.
Yeah.
So obviously DeFi stands for decentralized finance, right? And really the idea behind it is that you can take all of the complex higher order financial transaction logic that you get in traditional finance, what I might sometimes annoyingly call TradFi, because it sounds a lot cooler than CFI. So things like options, like lending, like swaps, like margin, margin trading, commodities, certificates of deposit, bonds, hypothecation, rehypothecation, foreclosing on collateral, you name it. All these complex things that make up the weft of our capital markets and our modern financial practices, and you can find ways to do similar things or have similar effects on basically on a peer-to-peer network utilizing a blockchain and operating on essentially an anonymous or pseudonymous basis, right? And so how do you do that? Well, how does TradFi do that? The way TradFi does that is it incentivizes people to do the things that they're supposed to do, right? And it primarily uses a combination of legal agreements, regulations, reputational scoring, and this sort of thing. And sort of combined with this idea that there's a legal system, there are courts, they'll enforce the legal agreements, and even if the court somehow can't get its result followed, there's this sort of implicit threat of state coercion behind it all, that they'll make someone pay or do whatever they need to do, right? And that's really how our financial system works, right? It's mostly legal agreements and courts with a little bit of reputation mixed in. Now, the trick with DeFi is to get the same results or similar results, but instead of it being an emergent phenomenon of legal agreements and courts, it arises from code running on a blockchain, and without people knowing each other and so forth, right? So that's the basic idea. And I think one of the critical things to note is that just because something is on a blockchain doesn't mean it's DeFi, right? In fact, many things like I would say Tether or like USDC, as an example, these are stable coins where one of the token is supposed to represent one USD. they're basically TradFi. What those are is, or what they're supposed to be is basically like a tokenized certificate of deposit, right? That some company has issued to people. And the reason why that token has the value of $1 on the market is because it's backed by a legally enforceable promise of the entity to give someone $1 if they give them the token. Right, so it's very similar to a bank. I would just consider that TradFi on a blockchain, right? So an example of how DeFi is different, right, is that a DeFi solution for that, which is called an example is called DAI, a stablecoin called DAI, DAI, is to try to get that same result purely through smart contracts and with no promises. Right, and so these smart contracts, which are just programs that live on the blockchain, you can give them essentially spending authority over, let's say $150 worth of ETH, right? And in exchange, they'll give you $100 worth, or what's supposed to be $100 worth of DAI, which would be 100 DAI. Right, because it's a stable coin, and the logic of the smart contracts are set up in a way where if the value of the ETH plunges enough in the market so that basically you've taken out too much DAI relative to the ETH that you put in, well, then someone is incentivized, and typically it's a bot, really, someone is incentivized to come in, trigger that smart contract, and essentially foreclose on your collateral, is how we would refer to that in the traditional system, because you owe too much debt, right, and you haven't paid it. So you can get very similar results, but not identical, right? And yet, and one way you can see that, right, is in my example, I said $150 worth of ETH to 100 DAI. Well, that's called over collateralization. And it's a form of capital inefficiency, right? That's less efficient than TradFi, where in many cases you can get a completely unsecured loan, but nonetheless it is similar in logic, and you could go down on the line. How do you do an option? How do you do these other things? It's complex, and we'd have to get into a lot of details. But that's the basic idea. Similar effects to TradFi, but using very different mechanisms, programs, and blockchains.
And so I guess the question is, I don't want to jump too far ahead. We're going to get to this, but take the example of DAI and Maker, something like it. I guess the question is, have we actually seen DeFi platforms that escape the legal frameworks or rubrics that apply to TradFi? In other words, it's an interesting concept, but I've always viewed this as opposed to getting rid of risk or liability, as actually just distributing it.
It's possible. I think we'd have to, that's a more sort of detailed question as to liabilities and so forth, right? In the case of MakerDAO, right, to stick with that example, you could view it a lot of different ways, and I think legally, and I think all have some credibility, because MakerDAO is run by, it needs the parameters to be adjusted from time to time to try to maintain DAI equal to $1. So that effectively means setting the interest rate on the smart contract and potentially the collateralization ratio and so forth. And so that means humans have to intervene. Now, typically, setting interest rates would be, in TradFi, that'd be like a bank or something, or maybe even a central bank, right? That's setting rates, maybe based on reputational scoring or macroeconomic factors in the case of a central bank. And in this case, it's these token holders who hold this token called MKR, and their proposals are put up and they get to vote on it. And rather than you taking out a contract with that unincorporated association of persons, instead you use the system that they've set up with the parameters that they want, and in effect you enter into an agreement with yourself, or perhaps you could see it as creating an option without a counterparty. Really, the system is the counterparty. So I do think the metaphors start to break down. Whether regulations care about that or respect that, is a different matter, right? On which I imagine we'd have a diversity of views. But as far as the contracts, I don't really think there are legal contracts going on here. It's something else.
Okay. Anybody else want to jump in on that point?
Well, maybe I'll say this. This is Ryne. So whether these are contracts, whether the regulations have something to say about this, I like to take a step back and think, what exactly, at least in the U.S., do our financial services regulators try to regulate? And there's probably two core silos. One is activities or functions, and then the other is persons or individuals. Sort of, we regulate certain types of conduct or activity or products, and then we regulate the individuals who are involved in those products. And so let's talk about a very simple example of a decentralized platform or product that allows you to trade one asset for another. One ERC20 token for another. The code is gonna recognize prices, match bids and offers, and execute and transfer the ERC20 tokens. That is a transaction in that we've got an exchange of thing A for thing B at a certain price that's been agreed to between two individuals. Whether that transaction is a derivative, a security, or something else, we're going to spend some time wrestling about. If that transaction happens to be a derivative or a security, we have two different regulators that say, if you've got a venue that facilitates these types of transactions, that venue, is a thing that we regulate. It's an exchange that has to be registered either with the CFTC, the SEC, whatever. And so, I'll stop here in a second. We're going to spend a lot of time wrestling with, is this thing that meets the definition of a venue, is that something the SEC or the CFTC are going to then jump into and say, now we need to find the person who is operating this venue? And that's an interesting question. And what factors might help us identify that person? And we can push back and forth against all of these, but who originally published it? Who's using the venue? Maybe there's a super user. Who updates the venue? And I think a really important one is who, if anyone, gets paid from whatever revenue spits out of this venue. So those are some initial thoughts.
And Rebecca, when we were talking yesterday in our prep call, I know you may not be able to get too deeply into the facts and circumstances, but you'd actually said that you had seen some functionality where regulators did, in fact, they didn't throw their hands up, but they did look at it and say, you know what, this is so distributed, so decentralized that we're not going to ask any, we're going to walk away.
So yeah, I'll put a little meat on that, and I'll also step back for a second. I mean, I've spoken on a bunch of panels about DeFi, and I think I always say decentralized doesn't mean unregulated. So I'll start with that. I'll start with that premise. And for any project in DeFi, they should be talking to lawyers, or at least thinking about regulation at the outset, probably even before they build. But let's say you've built already, then certainly, as you're thinking about launching, and let's say you've launched, then in between V1 and V2. But at any point in time, you should be thinking about regulation and the type of regulations we're all going to talk about today. So AML, KYC, the BSA, OFAC, Securities, CFTC, banking regs. If you're mimicking, I don't call it TradFi, I call it legacy finance. But if you're going to mimic something in legacy finance, you should think about what regulations apply to it. So lending, all of that stuff. And I'm in New York, so I always think about the bit license too, and do a lot of work with clients on that. But the regulators didn't throw up their hands and say you're too decentralized. What the premise of all of that was that there were no information asymmetries. Whatever the company that had developed the protocol and the interface had was identical to what the regulators could obtain publicly on the blockchain and otherwise. And so there was really nothing that could or needed to be done from the company's perspective. And so the regulator said, nothing to see here, we'll back up.
So we had a question. Let me tell you, folks, if you're putting questions into the chat, if you don't mind dropping them into the questions, there's a separate tab. That would be helpful. So before we get into the next piece, we're going to have Ryne talk about the DOJ's recent guidance. Jacob Ma Weaver asked a question that gets back to stable coins, which I think Gabe had talked about. And the question is this. Last month's SEC FinHub staff statement and OCC interpretation stated that stable coins might or might not be considered securities depending on the facts and circumstances. Are there particular stable coins you personally believe should or should not be considered securities? Does anybody want to tackle that? Or do we not want to be quite so declarative in our views? Anyone?
Well, I wouldn't propose to get declarative, but I'll touch on it. Many people have looked at stablecoins through a pure Howey lens, and I think that's helpful but not sufficient. And by a Howey lens, what I mean is the investment contract analysis, and have taken a relatively simplistic view that if there's no expectation of profit, that you can't have a security per se. But the definition of security in the Securities Act of 1933 is broader than just investment contract, and it includes a variety of other instruments, including instruments that would generally be thought of as a security. One of the challenges with some stablecoins is that if they are basically backed by a bank deposit, that itself is not FDIC guaranteed. And if you look at the OCC letter, I believe it's footnote 19, they actually get to this rather specifically, and the general rule for the pass-through of FDIC insurance is whether there's an identifiable end beneficiary. And for most of the stablecoins that have been created, there is not such an identifiable beneficiary, which means that you basically have simply securitized a loan to a bank, which is what a deposit is. And that, does start to look a little bit like a security. I think wisely, the SEC has not made this an enforcement priority, and I don't anticipate it to be one, but it is just an example of sort of overhang that you have in the regulatory framework. Ryne, I also just want to say that I think you're spot on with the distinction between institutional-based regulation and activity-based regulation. I think that's a point that is often overlooked and is really important as we move into the space. The move prior to the financial crisis to shadow banking, I think in many ways presaged a lot of what's happening in DeFi. In shadow banking, you had non-regulated entities providing financial services, and it all worked great until it stopped working and things went very haywire. And I think regulators are very sensitive to allowing another second sort of, more decentralized but shadow banking system to arise that could have destabilizing effects.
So I'm sorry, Rebecca, were you going to say something?
It's just going back to something Ryne said too on this venue point as well, and then talking about person. When you look at almost every regulatory scheme that we're going to talk about today, they do use the word person, and then they define it out to be obviously a natural person or an entity, and it could be, there's a great word that they use in the Dow report too, but like a loosely affiliated group of people or entities or whatever. But the question I think for DeFi is, let's say the protocol is super decentralized. The question is, and let's say you can make the argument that the transactions on this protocol are really peer-to-protocol rather than peer-to-peer. The question is, does a protocol or software constitute a person under these regulations? And I think that's something that a lot of the regulators are grappling with now for something that may be sufficiently decentralized, whatever that means.
So is there a legal or compliance risk to something like Uniswap, without particularly pointing to Uniswap, if their top traded tokens are stable coins? Somebody want to tackle that?
Well, to me, stable coins are probably the least of their concerns, right? People are using Uniswap, essentially to facilitate brand new token issuances, right? And in fact, Uniswap itself is using Uniswap for that purpose. Uniswap, the company, is using Uniswap, the smart contract, to distribute its governance token Uni, right? And so, as we've seen in the past, tokens that are newly issued, there can always be at least a reasonable question as to whether those constitute securities. And if they do constitute securities, then the next question would be, well, what does it mean for a security to be trading through this smart contract or through the website that reads data from the smart contract and enables a third-party wallet to send transactions to Ethereum that ultimately interact with that smart contract, and so on. The definition of a securities exchange in the U.S. is extremely functionalistic, let's say, and even had the foresight, way back when, to talk about even if it's run by just an association of persons, right? So, I certainly think that that argument could be made. An additional, forget about stable coins because, frankly, I don't think they're securities in nearly any case, but, probably some of these tokens at least are securities. The other question would be, and then if it is a securities exchange, well, what do you do about that, right? Because it's essentially just an appliance sitting on the blockchain. Do you punish Uniswap Corporation for deploying it? That doesn't really make a lot of sense. But then, maybe when they add a fee token, it's more like they're running it as a business, and maybe at that point, it could become a better argument. And then the other thing is the liquidity providers, right? Because the way Uniswap works is that, essentially there are what's called liquidity pools, and each pool has two tokens associated with it, and independent persons are incentivized to come in and to deposit those two tokens in the appropriate ratio, and then essentially that creates a price, right? There's sort of an implied price by virtue of that ratio of the two tokens. And so these liquidity providers who are depositing these tokens, well, they're just users in a certain sense of the smart contract. But on the other hand, if the tokens are securities, then, and since they're getting fees out of providing the liquidity, well, they start to look a whole lot like unregistered securities broker dealers. Moreover, even if they're not securities, right, FinCEN in its 2019 guidance had this section on what it called peer-to-peer exchangers, really thinking of people, like individual people, not businesses, who sort of make a business on like local Bitcoins or something like that, of selling Bitcoin. But these liquidity providers, it seems to me, would equally fall under that guidance. So there's also an issue, with respect to the money transition laws, which maybe money transmitter laws, which maybe Sarah could speak more.
That's exactly where I was going to go. We're kind of jumping ahead of our outline. I hope my panelists will forgive me, but Sarah, we had a kind of follow-up question from one of our listeners about BSA, OFAC compliance issues as respects DeFi. And for me, actually, I think the money transmission issues are of much more concern and present greater risk and are maybe slightly less understood by folks in the space than securities. It's funny, somebody in the chat said the Howey test is so 2017. I actually think it's 1947 actually. But maybe if you can speak to that, maybe again, jumping ahead a little bit, and Ryne, you'll forgive me, you're going to talk about the DOJ report. But Sarah, walk us through, if you don't mind, OFAC and FinCEN, who they are, what they do in like 45 seconds for people who don't quite know those letters, and then talk a little bit about the 2019 guidance and how it applies to a DeFi project. You don't have to talk about MakerDAO specifically, but sort of generally, how do you see it applying and where the compliance headaches are? Stage is yours.
Yeah, happy to jump in. I don't know that I will be able to condense it into 45 seconds, but I'll try my best. I saw something on Twitter a few days ago that someone posted the question, "What's the worst word in crypto?" And one of the responses was KYC. And I thought that's probably fair, or at least the cause of a lot of headaches for anyone who's building in crypto, and particularly in DeFi. And certainly, as I was hearing Gabe, you describe some of the, what does it mean to be a liquidity provider? One of the interesting things is, while it may be very 2017 to talk about the Howey test, the further you get from some of the securities lines, the closer you get to a lot of the money transmitter lines. And it's absolutely true that some of the biggest dollar value enforcement actions and lawsuits that have, and I should say criminal cases that have occurred to date in the virtual currency space have been with respect to money transmission issues. So it's definitely important. At a high level, FinCEN stands for the Financial Crimes Enforcement Network, and so that's the alphabet soup of FinCEN. And they were the first federal regulator actually to publish any kind of guidance back in 2013, largely had Bitcoin in mind. So most of it dealt with very payments focused kinds of regulations and thinking about how does Bitcoin fit within our payments infrastructure, regulatory infrastructure. And what they effectively said was whether or not you are a money transmitter for purposes of their regulations depends on whether or not you are an administrator, an exchanger, or a user of virtual currency. And if you're a mere user, you are not a money transmitter. But if you are an exchanger or an administrator, then you are. And if you are, then you have to register with FinCEN, develop an AML compliance program. And sorry, I realize I'm skipping ahead on alphabet soup again. AML is anti-money laundering. And actually that's important because that is why we then have KYC, know your customer obligations, because the whole point here.
How can something like a decentralized protocol like Uniswap, how does something like Uniswap or Sushi, how do users of those protocols or the platforms, the website that you go to, how does that fit within the rubric that you're describing?
Yeah, well, so the fun piece is that if you go look at the actual regulations, whether or not a person is a money transmitter is a matter of facts and circumstances. So as lawyers frequently like to say, the answer to your question is it depends. But more concretely, the reality is there is kind of this line of are you holding yourself out as being an exchanger? And the closer you are to holding yourself out as being an exchanger, the more likely that's how FinCEN is going to view you, and they're going to view you as subject to registration and compliance with all the money transmitter obligations. On the other side of the spectrum, you have me, who could be a customer of Coinbase or Gemini or Bittrex just as easily as I could be a counterparty on any one of these other DeFi platforms. And if I'm just a user, I'm trading with my own funds, trading on my own account, trading for my own investment strategy, then I'm far less likely to be viewed as a money transmitter.
In your view, does it matter for purposes of risk analysis for MSB purposes? Does it matter if a protocol uses proof of work as opposed to proof of stake?
I mean, again, it depends. I think at a baseline, if we're talking about Bitcoin versus Ethereum, I think I don't think that distinction is going to matter all that much. I could imagine, and I've heard, other scenarios involving variations of proof of stake where the entire platform is arguably not all that decentralized, depending on how we step back and define decentralization to begin with. And thinking back about what the definition of a money transmitter is, it's receiving funds and transmitting them. And if you are relatively centralized or completely centralized, take PayPal, for example, all of the funds that are being received are then also being transmitted on. And just because you're using a blockchain doesn't inherently mean that you get to say, well, it's decentralized and kind of, wave your hands. So, I don't know if that answers your question, but there's...
So Rebecca, you wanted to jump in there?
Well, I want to talk about something that Sarah said, because I think it's important for this panel, and I think it was sort of like a level setter, the same way that Gabe's TradFi background was. Can we talk about what we mean by decentralization, right? Like, I think there are a few different pieces to that, and I think they're important so that we all are, both the audience and we are all talking about the same thing. So, right, centralization means there's a small group of people or entities completely driving, let's say, the project, right? And it could be the company, it could be whatever it is. Decentralization means that not that there's no one controlling it, but as sort of Gabe and I think Lewis alluded to, that there is a more diffuse group that is making decisions around it, or that can basically make decisions without any centralized actor. So something like an AMM that's been deployed to the blockchain and has no company that has no admin, there's no company that has an admin key for it or anything like that. It's going to live forever. It can't be upgraded. So, right, that's decentralized. However, you could have a protocol that's been deployed to the blockchain and the company has an admin key, or a small group of people controls how it's being built or upgraded or things like that. That may have some elements of centralization. And the other thing you have to think about too is if you're running an interface that gives you access to a completely decentralized protocol and the company's running the interface may be centralized too. So there are lots of different pieces to decentralization and centralization that need to be considered when you're talking about DeFi and the law or regulation of something that's decentralized.
So software, that's really interesting because there's FinCEN guidance that suggests that creating and deploying open source software that allows somebody else to be a money transmitter is not money transmission, doesn't make you an MSB. But there's this great case that Ryne pointed out, a CFTC, it was a consent order, it was a settlement, Edge Protocol. Can you talk about the Edge Protocol case? And then I want to get back into this, the line between being an open source software provider and the risk associated with that and being something more.
Yeah, to jump in completely from left field or right field, it doesn't matter which field it is. What I've always heard from regulators is it's decentralized. There's no central person. We're skeptical. We're not willing to accept that, or at least we want to push on that a bit more. There's got to be an actor somewhere, and so there's some historical precedent. And this is a CFTC specific case. It relates to something called spoofing, which is a type of futures trading where you put in bids and offers and you cancel them before they're executed, and you do that as some sort of trick to other participants in the market. The allegations were there was an individual.
What's the name of the case, Ryne?
It's CFTC versus Edge Financial. Edge Financial.
See if I can drop a link in. Go ahead.
Yeah, and so it was a consent order where the CFTC and the company ended up settling. The Department of Justice had actually gone against the individual, and Edge Financial was his company, and the allegation was that he created software that he then sold to traders, and the traders used that software to do this quote-unquote spoofing. And without getting into what spoofing is, it's a type of trading activity that the CFTC thinks is not permitted. And so they said that this software coder, by creating that software and selling it to the trading firms, he sort of knew or should have known that the software was going to be used for some purpose that was impermissible under the CFTC's rules. This is not a hugely difficult concept. Knew or should have known. Were you reckless in releasing something, knowing that it could be used for some improper purpose? And so while the DOJ went after the individual and ultimately did not prevail in what I think was the right outcome under the Commodity Exchange Act, the company itself ended up settling with the CFTC. And it just shows you that sometimes the willingness of regulators to go after conduct is where we have to draw the chalk line, or at least put in our minds that there's a potential chalk line there, as opposed to what we might think the regulations say themselves. And that goes to Lewis's earlier point, is where is their enforcement priorities? In some cases, they're not going to go after the low-hanging fruit, even though it's obviously in violation. In other cases, they'll go after the largest fruit, even if it looks outside of something that's violative because of their own policy priorities or preferences.
Let's talk about that large fruit. Lewis, I want to have you talk about the Quintena's speech in a moment, but it's actually kind of appropriate that we talk about BitMEX now, which someone just asked about. And the BitMEX case, I'm going to ask Rebecca to talk about that, and you as well, Ryne. The BitMEX case specifically involves the Commodities Exchange Act. There's a CFTC enforcement action, and as well parallel DOJ criminal prosecution for violation of the BSA. You want to talk about that a little bit, Rebecca?
Sure. So the biggest news was a couple of weeks ago. There were, as you said, parallel actions. One, a civil action by the CFTC against BitMEX for violations of the Commodity Exchange Act and the attendant regulations. And then, as Stephen said, a DOJ indictment came down for criminal violations of the Bank Secrecy Act. So on the sort of what we're all talking about and a little bit more comfortable with now is the civil action side of things, where the CFTC said that BitMEX knowingly and willingly violated the Commodities Exchange Act, and that's just going to proceed apace. BitMEX's lawyers and the individual defendants, said they're going to vigorously defend themselves in this suit. But it basically was for the reason that BitMEX, which is a centralized exchange, as we talked about, run by a small group of people, and the CFTC's complaint really focuses on the small group of people who are at the helm of BitMEX making decisions and knowingly violating the CEA. are liable, or are at least trying to be held liable at this point. And these are just complaints, so they're allegations at this point. As for the indictment, again, and this is sort of the more relevant, the more relevant point to think about, notwithstanding the fact that BitMEX is centralized, that when we talk about the Bank Secrecy Act, and I know Sarah can talk to this as well, and that we talk about the obligations, if you're a financial institution, and financial institution has a very specific meaning. So you're something like a futures commission merchant under the Commodity Exchange Act, you have obligations to comply with the Bank Secrecy Act. And that includes putting in place AML and KYC plan, reporting SARs and things like that. And the DOJ and the BSA carries with it criminal liability. So to the extent that you knowingly violate the BSA, you're now criminally liable, and that's what the indictment has against BitMEX. Again, this is a centralized group of people, I think the other important takeaway, and something we talk a lot about in DeFi, and I talk to my clients about a lot, and I'm sure everybody here too, is BitMEX incorporated in the Seychelles offshore to try to basically avoid being in the United States. Incorporating outside was not enough here. Both the CFTC complaint and the DOJ's indictment talks about BitMEX's extent and their founders and controlling centralized actors, connections with and contact with the United States. They had tons of employees here. They had headquarters all around the United States and things like that. So when, let's say you're a DeFi project and you're going to be centralized to start, I think everybody has to just accept that, because you're creating a protocol and launching software, you're going to be somewhat centralized. You have to think about if you want to be in the United States or not. And that's, I think, something important to take away from BitMEX as well.
So what was the name of the DEX in Chicago 2 years ago that got shut down? Do you all know?
Ether Delta?
Ether Delta.
Ether Delta. So somebody want to, we didn't talk about this yesterday, does somebody want to kind of summarize the Ether Delta case, perhaps why that's relevant? Because the question that was asked in the chat was well, BitMEX, that's a centralized exchange, and you're talking about DeFi. Why does any of this matter? And maybe speak to Ether Delta. Was it Lewis who wanted?
Maybe I'll just pick up quickly on that. So Zach Coburn had created primarily the Ether Delta nominally decentralized exchange, and it allowed a wide variety of tokens to be traded on it, some of which the SEC alleged were in fact securities, although in the actual settlement with Coburn, they never said which securities they thought were, which tokens they were the securities, but let's give them that. Coburn had actually disposed of his interest in the business and the code to an undisclosed buyer. And by the time the enforcement action came around, he no longer controlled it, but he did have the keys, the administrator keys to the smart contract, and was also had given himself effectively a cut from transactions that occurred on it. And that was enough for the SEC to say that functionally.
Too. Sorry to jump in. The centralized order book is really important. Yeah.
So,
no question about that. Yeah.
The 2009 FinCEN guidance, and I'm looking at you, Sarah, that guidance, there's a distinction between custodial and non-custodial that I think is significant, but is it enough for purposes of an MSB analysis? If you're looking at a protocol and looking at the people who are creating it, is it enough for them to say, we don't hold funds, we're non-custodial, therefore we're not an MSB, or is there more to that analysis? And again, shifting from the securities analysis to the financial regulation analysis.
Yeah, I think there's more to it. I think there's a lot to talk about on the custodial front. I think a lot of DeFi projects are not actually all that decentralized. They're just not custodial, is a sort of baseline and level setting. But related to both that and kind of the topic of, can you just go offshore, or does it matter that you're an organized entity? The actual definition for a money services business, of which a money transmitter is sort of a subset, includes persons wherever located doing business, whether or not on a regular basis, or as an organized or licensed business concern, wholly or in substantial part within the United States. And it goes on. And so, the rule writer said, we don't care if you're an organized business. We don't care where you're located. We care whether you're involved in the activity that we're describing here. And Ryan, I think that's a point you made earlier. But to tie that back to the 2019 FinCEN guidance and why they, honestly, I think the analysis was kind of light on this front, and maybe intentionally so. I think there's barely more than a paragraph where the 2019 FinCEN guidance talks about decentralized exchanges, and they actually don't talk about custody. What they talk about is a different exemption from the definition of money transmitter, which is that you are not a money transmitter if you merely are providing delivery, communication, or network access services used by a money transmitter. And when I'm talking to clients, I frequently will use the example of just because you're a cell phone service provider or an internet provider that is necessary in order to use your Venmo app does not make, the network provider does not make Sprint or T-Mobile a money transmitter just because their services are necessary. And obviously, that line, we're a lot closer when we're talking about DeFi projects, but that's actually the piece that FinCEN, the piece of the regulations that FinCEN referenced when they effectively said, well, as far as decentralized exchanges, we know they're out there, but if all you're doing is providing network and delivery and communication services, then you're not a money transmitter. They didn't actually address the custody piece as far as that bit of the analysis goes.
Yeah, I always, oh, sorry. I look at different decentralized finance projects and what they've released in terms of the product, and I think, is this just a hyper functional version of email, or is there something else happening on there? And does the code take it a step farther than just bringing a lot of efficiency to what we would otherwise communicate? Would you like to trade? Yes, sure. What's your price? Okay, send the money here. And if the code goes a step further, and I think custody is a good point, and does something, then we got to think harder.
So I think that's the key. What you're saying is custodial, non-custodial, that's important, but that's just one way of considering whether or not someone has MSB registration requirements or CEA registration requirements or SEC registration or exemption requirements. You have to look beyond custody, non-custody. That's almost like a red flag. Louis, the Quintena's speech. So Brian Quintena is a CFTC commissioner. He gave a speech 2 years ago in Dubai, was it? And one of the things that he talked about I thought was interesting was that it's almost like if you if you loan somebody your car and they get into an accident, if you knew they were drunk, you might be responsible. If not, you wouldn't be. The car manufacturer, if the car worked properly, probably wouldn't be responsible. And maybe that same logic applies here. Maybe tease that out a little bit and talk a little bit about that speech and what might be helpful from it for our analysis. I reread it this morning, and it's actually pretty neat.
It's a great speech. Yeah, drop a link. So Quinten's is a CFTC commissioner. I think he's retiring at the end of the year. And he was speaking particularly about prediction markets, which has been a subject near and dear to a lot of people in the crypto space. And folks will know there are two main projects out there trying to create decentralized prediction markets, Augur and Gnosis. And he's focusing, I think, more particularly on Augur and the idea that you can create a platform that allows people to write smart contracts that may do activities that would be considered, at least if offered to retail persons in the US, a regulated activity. And an event contract of the type available on Augur would fall into that category. However, yeah.
For the folks here who aren't CAA mavens, what's an event contract?
Sure. So an event contract is generally a binary option in which the outcome of a particular event, yes or no, will Trump win the election, creates a payout in one direction or another. And generally speaking, event contracts are considered commodities under the Commodities Exchange Act. And unless you have an available exemption or no action letter like Predict It run out of Australia, you would have to do that on the designated contract market.
Let me ask you this, Ryan, and this is maybe from your perspective as having actually been with the agency. Why does anybody care about being able to bet on an event? Why is that something that is highly restricted in the United States?
Let me give you the legal answer. So gambling, the Commodity Exchange Act does preempt 50-state regulation. And so if you can get something inside of the CFTC's jurisdiction, you don't have to worry about 50-state laws. And one thing that Americans love to do, as the world does, is gamble on sports-based event contracts. And currently that's a state-regulated area. And the CFTC has said, we don't want to get into it. So as a public policy, and the Commodity Exchange Act gives them the authority for this, we're not going to permit certain types of contracts to trade on our markets as against public policy. And some of those include sports-based contracts, political event contracts, et cetera. And so they've deferred it back to the 50 states. And so if you want to do event contracts, you got to go around to your 50-state gambling regulators. That doesn't help you too much, other than to say the CFTC wants to set its public policy around, price discovery for the markets that are the real economy, and that's where they want to focus their efforts. Is that good or bad? Can we innovate on that? Sure.
Yeah, I would just pick up. Go ahead, Stephen.
I was handing it back to you.
No worries, because I think, Ryne, that's a super important point that comes up in our practice often, frustration on the part of clients. They're like, gambling, what's gambling, and why aren't commodities markets gambling? And in many respects, they are gambling, but they're gambling in a sanctioned environment with a very significant number of rules and core principles that surround how those markets work. So in many ways, the difference between prohibited gambling and permitted commodities contracts are the venue in which they take place and the rules and constraints that are around them. It's very difficult to actually tease out where the line is otherwise. But Stephen, I wanted to make a related point, which is all of this discussion, I think to some extent in my mind, misses a kind of larger point, which is we're largely applying we're talking about traditional finance, TradFi versus decentralized finance. I think we need to step up a level and look at the kind of regulation we're applying. Largely, we're talking about regulation that made sense for having centralized actors of one type or another, where you could punish them if they did something wrong, and that punishment would be meaningful. They'd stop, they'd be financially penalized, and perhaps they'd go to jail. That makes less sense in a more decentralized world where you have an unlimited number of actors that are going to continue to do the activity. I would assert we need a new perspective on regulation, which is encouraging compliance rather than discouraging or punishing non-compliance. Because fundamentally, we will never, what is our goal with financial regulation? Sarah, to your point, terrorism is not good. This is anti-terrorism finance. Financial crime is not good. We're all negatively affected by this. And I think we all share a goal of trying to prevent that. And we want regulations that are effective. Punishing people, and you go on Twitter and just say, well, I'm going to just, go more in the other direction. For anybody who's ever raised a teenager, punishment is often not a very effective tool in getting the behavior that you want. So I think part of our discussion needs to be, how do we rethink the way we're regulating, and how do we provide tools to allow people and encourage them to want to comply rather than for punishing them for not complying.
I'll clap. I don't know. I agree. Yeah.
I'm just a simple country lawyer.
Yeah.
To be honest, but no, that's I think that's certainly a good point. I mean, I guess the question is, why does crypto need special treatment?
And DeFi particularly. I mean, why do we need an unlimited number of actors out there throwing up, many exchange places?
Yeah, I'm not sure I necessarily follow, but I'm not a policymaker. Rebecca, you were going to say something?
Yeah, I don't know why. So I think if you're in the space, there has to be some belief that there is a benefit to moving away from legacy finance. I'm not, it's not going to all be torn down tomorrow, but to Sarah's point when she introduced herself, I think we've seen time and again that centralized actors aren't good actors on their own, that there's tons of rampant fraud, right? People are saying, oh, there are projects in the space that are fraudulent. I mean, I worked for many years of my career on the mortgage-backed securities crisis, and I don't think there were tons of good actors necessarily, when that was all going on either. So there has to be some benefit, and if you're going to work in the space, to believing in decentralized finance and the need for ways that people can transact that are new and different. I don't know if I'm 100% in Lewis's camp that we need to change regulation. I do actually agree. I'm not raising teenagers, but I'm raising much younger children. And I'd say, reward is always always produces better behavior than punishment. But I do think that, at least with the clients that I work with now, the reward of being able to grow and build, including in a decentralized manner, including for people who really believe in the benefits of decentralization or DeFi, the reward of that at least is incentivizing them to think about regulation really seriously as they build.
It seems to me, I mean, not to be cynical, but I believe that most projects out there are about making money, generally for a small group of people.
Not all my clients are doing that. In fact, I ask most of my clients, how do you think you're going to make money? Do you have a plan? And a lot of them say, no, we're just building this.
Right, and then they need money to build it, and then a VC comes along and says, you know what you should do? You should add a governance token.
Yeah.
It's great because it basically lets you have all the benefits of a registered securities offering with none of the downsides, and won't this be great for everyone?
I'm with you, Rebecca. And that's what attracted me about Bitcoin initially, was it solved a problem, a technical problem for me. At least I thought it did. But I want to actually, the governance token piece, that brings up something that doesn't get talked about too much, and that was raised in the Dow report back in 2017, 16, I can't remember when that was exactly.
July 2017.
But it's the 40 Act, the Investment Companies Act. Who wants to talk about the Investment Companies Act and how that might or might not apply to DeFi projects? I think it's overlooked, maybe because it's dry. It's dry and highly technical. But I think
I can do it. I mean, it mainly comes up in the context of DAOs, right? So, if you're interested in the LAO or you're interested in Metacartel Ventures DAO, which I'm involved with, these are serious issues for them, right? Because, an investment company is something that, people invest in order to sort of pool their money together and then make investments in other things, right?
How is that regulated in the United States?
Yeah, so there, essentially the logic is similar. It's regulated under the securities laws, right? It's a separate act, the Investment Company Act of 1940, as you said, and the, it's very similar, a very similar sort of pattern, right? If you're if you're sort of sufficiently small and private, then you're fine, right? 100 or less, shareholders, give or take some quote unquote knowledgeable employees who don't count toward that number, and less than 10 million in assets under management, right? And then you don't have to do big public reporting with the SEC. Bigger than that, then you have to do the public reporting. Right, and this actually dovetails as well with tax rules, right? Which sort of treat public partnerships differently, and I think really the intuition behind both of those, and this gets at a related point mentioned in the Dow report, as there's actually no such thing as a public partnership. As soon as a partnership becomes very large, it's no longer a partnership because the coordination is unscalable. And partners are the types of people who all know each other and can coordinate easily and don't have information asymmetries and so forth. And so, an additional consequence to throw in with that Investment Company Act reporting and the tax thing is just whether the securities laws apply at all as between what would be the investment company and that company's members, right? So, the Dow was in the position of the investment company, right? And it had these members, and the question was, because the Dow hadn't made any investments yet, so this had nothing to do with its investments into other things. It was all about the relationship between these people and this possible investment company, and it had way more than 100, right? And the big point, one of the issues the SEC considered is under a case called Williamson, general partnership interests are presumed to be non-securities because as Rebecca was saying earlier, earlier, there's no information asymmetries. Everyone is involved directly in sort of growing the pie, and they don't need the protections of the securities laws from anyone else. Well, if you have so many people, the SEC said, then they can't properly, and some, especially if there are some who can coordinate more easily with one another, like the curators and the Slock-Itch team could more easily coordinate with each other, then it can't be a general partnership, even if you say, hey, this is governed by all of us. That's just giving people a nominal voting right, but you need them to actually participate and have an ability to coordinate for that to be the case. And I think this is very, very relevant to the governance token thing that's going on, right? Because the whole theory behind that, right, is that, everyone has a say now in this thing, right? It's not being decided by a company, it's being decided by all these token holders. And so it's sufficiently decentralized and it's not a security, right? Well, yeah, maybe not, right? Because, if there is a company, right, and it's venture capital backed, and all the investors and all the employees in that company, they all have tokens and they all also have equity in that company, they all know each other. Well, those people can coordinate with each other incredibly easily. Right, and the other people who just got airdropped the token, they have virtually no ability to coordinate with each other because they're all just.
They could, but that doesn't mean they are. That doesn't mean they're coordinating with each other.
It doesn't mean that they are, but it's a
structural. Make it a security.
It's a structural. I'm not saying it makes it a security, but it makes it it makes it at risk of those partnership arguments not applying because you have a control block in effect. Now those people may all be.
At the same time, the liability doesn't then run to the company; it runs to the people who are coordinating.
I didn't say anything about where liability runs. I
was just putting a fine point on it.
Sure, but so again, I'm just raising this as an issue. I'm not pushing one specific.
So let me ask you a question though, and maybe Rebecca, you can amplify your point here. The Investment Companies Act applies even if you don't have a corporation formed, right? So it's possible to create an investment scheme that's subject to the act, that exposes people to securities law, liability and obligations, and that doesn't impose it upon a centralized entity. To me, and that gets back to the notion that decentralization can distribute risk as opposed to centralize it.
Sure. I mean, that's, and in some ways that's what I'm saying. I think as Gabe and I both said earlier, and I think Louis too, the securities laws have this idea of this loose affiliated group of entities, an unincorporated organization, something like that, which is what they talked about with respect to what the SEC talked about with respect to the DAO. But what Gabe and I were sort of going back and forth about is with these governance tokens and in terms of the various different actors, you can reapportion liability, right? So if the company's deployed their protocol, has no involvement with the governance token, company may not have any liability whatsoever, and the security and whether the token liability what?
Liability for what?
I'm literally just about to say it.
Okay,
so
great.
for the token being a security, right? They're not driving the value of the token and making it a security. But if you do have, as you were saying, this group of individuals, maybe unaffiliated with the company, maybe token VCs who got tokens, through their investment or something like that, and they're all coordinating and driving the value, then sure, they could be liable for creating a security because the efforts of others didn't mean the person who created the asset in the first place.
Yeah, there are multiple routes through which something like that could be a security. One would be the scenario you pointed out, right? The SEC guidance even talks about the possibility, which I think is very speculative at this point, but they said it of, something from turning from a non-security into a security by virtue of, an active participant emerging, right? That which is sort of the scenario you painted. But, even an additional possibility, right, is you have to look at the value drivers for these tokens. Why are people expecting them to go up in value? One reason is just because it's a well-designed protocol, and just by its ordinary course of functioning, it's going to attract more people, and that's going to create fees, and that's going to have value. And that wouldn't be a security, except under sort of a very obscure, viaticals line of cases about which there's a circuit split. You put that to one side. But on the other hand, if the reason why a lot of people are buying them is they're buying uni that is indexed to the deployed smart contracts known as Uniswap v2, too. But the reason they're buying Uni is with a reasonable expectation that Uniswap, the company, is developing Uniswap smart contracts v3, and that when they deploy the v3, that also will be tied to the Uni. Then that could be, a reason why Uniswap, the company, could be a securities issuer. And it's just a matter of looking at what the value drivers are and making an assessment, of whether the Howey test is satisfied.
Right. The only one thing I'll say is the expectation has to be reasonable, and I'm not sure the logical leap you made is reasonable. But
no, I didn't say. I just said if they have a reasonable expectation, then
sure.
yes.
Well, Steve, I just want to jump in because often, Gabe and I, we disagree very vehemently or we agree very vehemently. So we have to, it's like an alternating thing. But here it's an agree vehemently. And Rebecca, I would add one further point to what Gabe was saying, which is just the practical point about distribution. When you have a governance token held by a relatively modest number of people, all of whom are either computer developers or crypto heads or folks who understand and care about it, it's much easier to make those arguments. The problem is that, for most people, after a long day's work, in their home office, the last thing they want to do is get on and start reading details about what's going on with the DAO and how do I spend 3 hours of my evening decide how to vote on something. There's a reason we have distributed ownership, because people just don't want to do that. They just want to make the money. And I think we have to recognize that very practical overlay to all of this discussion.
Distributed governance. I mean, I talk to clients about this all the time. You really want to have 5,000 people who you don't know involved. Having 10 partners is a pain. There's so much to cover here.
If I can make one parallel point, though, before we...
Go ahead, Sarah.
Thank you. Just a parallel point of, even if we get to a state where we say these governance tokens are not securities, even if we could all agree that there's an example of a governance token that's not a security, going back to the less talked about but first litigated FinCEN example of what makes you a money transmitter is an administrator. The very first enforcement action that FinCEN brought was for both money transmission and administration against Ripple. And so just because you're not issuing a security doesn't mean you're just in the land of the free. It just kicks you back into the bucket of, well, now you might be a money transmitter.
Exactly where I wanted to, what I wanted you to talk about. And I want to go even further, which is with OFAC. OFAC, you can talk a little bit about this. OFAC has no intent requirement. It's strict liability. Either you comply or you don't comply, and if you don't comply, oh fuck, right? It's the other name for the agency. I'm curious about the exposure or liability. Let's say I've got a governance token and I send it to an SDN, or I send it to somebody in North Korea or Iran. Not making any normative judgments about doing that, but you can't do that if you're in the United States. How do the administrators in these schemes, how can they address or ring fence that OFAC risk, or is there really no way to do it?
There's no absolute way to do it. Again, because of how most of these protocols are built. The best you can do is create some kind of OFAC compliance plan. And usually what that ends up meaning is, to the extent possible, doing things like IP blocking, depending on exactly what's going on. If you really are doing something where you have some level of KYC, maybe it's not all the way up to what you need as a money transmitter or a FinCEN compliance program, but in a very English language sense of the word, you're maybe collecting a name and an email address.
What about this fact pattern? What if I'm a mining node and I am completely oblivious to the data that I am, in effect, ultimately, that I'm moving? If you are a miner, you are at some level, you are moving value from one place to another and one person to another. Does somebody who acts or serves as a mining node in a decentralized protocol nonetheless face OFAC exposure for and in respect to the underlying transaction?
I mean, this is the great question that we're not supposed to ask, because that's the Bitcoin question. I mean, we've had several regulators tell us Bitcoin is decentralized, the Bitcoin network. It was sort of landed on that, but you just sort of push back. Still, even if it is decentralized, do the participants, whether it's the miners or others, create some risk? I don't have the answer to that question.
There was a Treasury statement that was issued on the last day of September that dealt with ransomware. It's not directly related to crypto, though it did deal with Bitcoin. And it basically said, if you get a ransomware threat and you participate in paying money to somebody who's in a blocked country, you violated federal law. You are in violation of OFAC regulations. So you can't do that. So I guess the question is, how does that exposure inform the risk analysis of somebody who wants to participate as in some way in a decentralized infrastructure, providing processing or providing some sort of staking service? Do we not know the answer to that yet? Do we need to get action letters or administrative rulings from FinCEN?
I mean, Sarah gave the best answer, which is, what's your plan, right? What's your compliance plan? What's your red flag, alert, escalation, and resolution program?
Is a mining node really going to have a compliance plan, and are they going to like send SARs? How do you do that if you're oblivious to the encrypted data that you're transmitting?
Sarah?
Yeah, I think it comes to, well, I mean, I don't, the candid answers, I don't think anyone has this completely figured out, probably even OFAC. And that's why what matters is, what do you have? Because it is strict liability. And so if you play this out to conclusion and you end up in a universe where you have to explain what you did, yes, maybe you had transactions that went to someone in a blocked jurisdiction or someone on the SDN list. But if you had controls in place to prevent doing that or to avoid doing that on any level, then you can read any kind of OFAC case that's out there. The better controls you had in place, the more that's a mitigating factor in what you're fine.
But this is why I think design is critical. Right, the way these things are designed, and this is why I'm adamantly against all. Oh, it's blockchain. Just carve all the blockchain stuff out of the regulations, right? Because the reality is, the ones that are properly designed, I don't think they have this issue, right? Now, like for example, I represent someone who does a lot of staking as a service. Right, but they only do it on a certain type of network, and it's basically ones that are Cosmos style networks for the most part, or Tendermint style, let's say, of which Cosmos would be an example. And the brilliant thing about Cosmos and Tendermint, and I don't know if they thought about this as they were designing it, or if it's just a happy coincidence, but it is truly non-custodial in the sense that, yes, there is this finite validator set and people need to delegate to someone to do the staking for them, but the protocol mediates everything, right? Not only does the people who are delegating not have to send their tokens to the staking service, but the staking service also doesn't get their rewards. Right, and the protocol just distributes that to them directly. So that type of staking service, I think, can very legitimately take the position that they are merely a provider of, essentially an HSM, and some fancy networking tools, and they're basically being hired because they're very good at keeping network uptime and nothing to do with money transmission. Now, contrast Tezos, for example, right? For Tezos, there is actually a website out there, I forget what it's called, that ranks all of the validators in terms of trustworthiness and so forth.
Yeah.
Well, why? You ask why? Well, because they get the rewards, and then they distribute them out to people, and sometimes they steal them, and they compete with each other by dilating and contracting the percentages that they give back, and letting everyone share in everyone else's in certain ways, and so on and so forth. And so that's a bad design from a legal perspective.
The closer you are to providing processing service, providing compute time, or transmission, just pure data transmission, the further you are from financial regulation is my general view. And sort of working with people in designing things. We have like 10 minutes left. I don't know how that happened. We've got a bunch of questions here. Go ahead, Lewis.
Yeah, well, one of the questions was on banking. I know, and we haven't really touched on banking at all. So maybe does that work? Should we talk a little bit about?
And you, I don't know how much you can talk about
lending laws.
Yeah, and I know you worked on the Wyoming Special Depository Institution.
Yeah, I was going to talk more about in a DeFi sense.
Yeah, please.
So one of the questions that often comes up is if there's lending that's taking place through a decentralized protocol, is that something that's going to be subject to bank regulation and lending, licensing rules? And that's yet another very complicated thing. And I know some have argued that over-collateralized lending isn't really lending of the type that banking regulation applies to. I personally don't really ascribe to that view, but that view has been put out there. I think probably the more promising angle, at least in certain states, is that most banking laws apply to the lending of money. And if you're only engaged in a crypto-to-crypto transaction, there's a better argument. The state of Pennsylvania is one of them. Let's like that you don't need a lending license to lend crypto against crypto. So, for example, Stephen, if we lived next door to each other and you needed to mow your lawn, and I lent you my lawnmower, and you gave me as collateral, because you're a little shifty and stuff, you gave me a collateral, a collection of your whiskey, and you said, hang on to the whiskey until I give you back the lawnmower. That's probably not the kind of lending transaction. And even if I did that for everybody in the neighborhood as a business, and that's how I made money, that's probably still not subject to a lending license, because nobody's lending money. I'm lending, in that case, equipment. So there are arguments for that. But some states are all the way the other end. Washington State in particular is very aggressive the other way. And I just remind folks, some of us were around for the original peer-to-peer lending boom, sometimes known as marketplace lending, where people thought they created a platform, and then individual retail users would lend to one another, and that ultimately got functionally shut down in terms of being forced to comply with lending laws and also securities laws as well. So I think I would just, keeping it short, be very careful in any lending-based platform that I was doing to watch those rules, particularly on a state-by-state basis.
There's a really interesting question here. Let's see, where did this go? This is one about bankruptcy law. Where did this go?
About staying, well, the question was, I don't have it in front of me, but the question was a great question. And I wish Drew Hinkes was on, because he's the expert on this question. But basically, say someone is providing liquidity to a Uniswap liquidity pool, and that person goes into bankruptcy. When someone goes into bankruptcy, there's an automatic stay that applies, to basically creditors' claims, right?
That means that
creditors are not supposed to force. Yeah, and so does the automatic stay, apply to their assets in Uniswap? These are great questions. I'm not a bankruptcy expert. I don't think we have one on, but whoever asked that question should go to Twitter and look up Drew Hinkes, who's an attorney at Carlton Fields, and he's said a lot about this subject.
So I would say I do know a little bit about bankruptcy stays in litigation. I would say that, and the bankruptcy, the statute is very, very broad. Any asset of the bankrupt is subject to the stay. Now, the hard part is you can't take it, right? So if I've got money in a bank account, if I own a house, if we've got a contract and you sue me, all of that is stopped. Everything is subject to the jurisdiction of the bankruptcy court and the trustee. The problem is, if you've got something that's automated, where the owner of the thing doesn't necessarily have control of it, you have I suppose the issue would be ownership. So the question I would look at if I were the trustee would be, well, do you have control over that? Do you own it? Do you know who the other people are who have a right to that thing? I'm probably going to take the position that it's subject to the stay. And
Sure.
but I hope there's litigation over this. It's very-
But yeah, and it gets even more complicated, right? Because ordinarily the remedy would be, okay, basically it's an encumbered asset, right? It's encumbered by this stay. So if someone gets it, right, the idea is they take it subject to that encumbrance, and they might lose out, because you want to strongly incentivize people to figure out whether the assets they're getting are encumbered by a stay or not, and that's how you do it. You subject them to a risk of forfeiture. However, out of this liquidity pool, particularly since you're not talking about Bitcoin, and so it's not a UTXO model, it's an account-based model. How do you know which person got that ETH or whatever it is, right? You don't. There's no way of knowing. Do you punish everyone? I mean, it leads to kind of wild thinking, and it's sort of just like doesn't work, right? But it's interesting.
It might stink the whole pool up. That's the risk.
Is that a herring reference?
No, not everything's a herring reference. Interested in opinions.
I just put a key. I'm sorry. Just because I put in the chat the article, Gabe, that you referred to. That's indirectly related to this about compelling the revelation of keys, because that's in many ways that's what it boils down to. It's a great article by Drew Hinkes, and I absolutely recommend it to folks.
How do we feel about referral programs in token sales? Actually, I do want to ask, if we were doing this a year ago or 2 years ago, we'd be talking about token sale litigation and no action letters. I suppose, do we think...
But this is the perfect time to talk about this, because there's actually been 2 cases decided this year.
I think Rebecca was going to talk about Kik and Telegram. We have a little bit of time. I'm kind of curious, is the law fairly settled on the use of tokens to raise money? Do we now have an answer to most of the questions that surround that? And is the use of tokens something, I guess the next question is, do we need these things for quote unquote DeFi?
Well, I'll take your second question first. I think you need certain tokens for DeFi just in terms of how the protocols operate. Governance tokens aside, there are these native protocol tokens that help make the protocols work properly. I guess you could argue you don't need them, but I think they're critical.
Maybe they could be called something other than tokens. I realize tokens is a software term, right? You can have a token, obviously, that has nothing to do with securities laws. But it's
I don't think the word token has anything. I think maybe in this circle it's taken on different meaning, but I think every regulator will tell you it doesn't matter what you call it. It matters what it is and the facts and circumstances around it. As for using tokens to raise money, I don't think that's what Kik or Telegram were about. I think it was a series of understandings and agreements, some of which included the distribution of tokens to solicit business. And so to solicit investments. And so for that, the way it was done was improper. And so, and both Kik and Telegram found that. And so I think the way it was done there with a SAFT in one instance and a purchase agreement in another was really improper.
The problem here is that, the state of the market for issuing tokens has moved on dramatically, right, since 2017, right? And so so much of the SEC guidance, other than the Dow report, right, and these 2 cases that were decided were about so-called utility tokens, right? Now we have these governance tokens, which interestingly, from a superficial perspective, look a whole lot more like securities than utility tokens ever did. But on the other hand, because they have fee, they have a right to get fees, or a power to get fees, you could say, that have accumulated, and they have voting, but on the other hand, in the meantime, there also has been this thinking, somewhat even embraced by the SEC, right? Yet to really be embraced by a judge, but around decentralization, being meaningful in the sense that it, can cause the securities laws not to apply or to cease applying when they otherwise would. So it's very, very interesting where we've ended up, where we have things that, if anyone had been selling governance tokens in 2017, I guarantee you everyone in the space would have been like, well, the utility tokens, that's one thing, but these governance tokens, they're obviously securities. And now it's the exact opposite. The utility tokens are like, oh God, those are definitely securities. But these governance tokens, decentralization, and so it's very strange how we've ended up here. And again, I'm not saying the governance tokens are necessarily securities either, but I'm just marveling, at the bizarreness.
Well, and like from a nomenclature standpoint, it's precisely opposite. I never liked those terms. I never liked the term utility token because they never were. But at least nomenclature-wise, utility token, at least in theory, if it actually had use and was not being sold to raise capital purely, probably not a security. Whereas a governance token sure sounds a lot like a share, like voting stock in a company. We have so much, we could do this for hours more, but I want to respect everyone's schedules. I want to close by asking everybody if they're willing to make a prediction about, I'm really interested in what it is that we're going to be seeing in litigation in 2 years. Like, 2 years ago you had ICOs, and we'll still have that hangover, and we'll probably have it for a few more years. What's the tail risk? What's the hangover going to be of DeFi, sort of broadly written? Sarah, let's start with you.
I mean, litigation risks are not my specialty, but honestly, I think we're gonna see a lot of projects today that are the kick and telegram of 2 years from now. I think there's going to be a lot of projects that, despite making some attempts to do things correctly, are still going to find out that the activities they were engaged in were regulated. And so even, notwithstanding some moderate amount of structuring advice, will end up being the DeFi examples we're talking about in 2 years.
Gabe, next to you.
I will say that within 2 years, there will be a private litigation by some governance token holders against some other governance token holders or some developers involved in the project, alleging that they did not properly respect the rights of the governance token holders in a fork or adding a feature or something of that nature, because a lot of these things are ill-defined as to exactly, or I'll say underspecified in terms of what they actually are supposed to mean and do, right? So I'll predict that.
Ryne, let's go to you.
Yeah, I'll comment this from a different direction. I think there'll be some conduct-based inquiries, whether it's manipulation, fraud-based, something based on transaction activity, just because that's my background. Something there.
Okay, cool. Lewis?
I think we're going to continue to see private plaintiffs step up, and the plaintiffs bar are, as long as they can be financed, they will look for opportunities. And I think the plaintiffs bar provide an important role. Often as transactors, we don't like that, but they clean up the underbrush of the jungle. And I think we'll see the plaintiffs bar remaining or becoming even more aggressive in the crypto space.
Rebecca, I'm going to give you the last word, which means I'm going to make my prediction before you.
Okay.
So my prediction is we're going to see significant litigation. We're going to see significant enforcement activity involving the Bank Secrecy Act, state-level equivalents. We didn't really have time to talk about state today. And OFAC, I also predict, and this is the centralized space, I predict another exchange is going to get BitMEX hasn't been taken down yet, but I predict another exchange is going to be on the receiving end of significant enforcement activity. And we'll probably see that happen with respect to one or more of the significant DeFi platforms now. Rebecca, last but most.
My prediction is that everybody is right here. I definitely think Lewis is right. There's going to be a continued spate of private plaintiff actions, both lobbing off of old projects, right, that aren't even DeFi related, that they're crypto or blockchain, whether they're centralized exchanges or centralized projects or token projects. So I think that's definitely going to continue. I do think we are likely going to see various regulatory agencies come out in different ways on DeFi projects, both on the money transmitter OFAC side. I think Treasury is probably giving some thought to what needs to happen moving forward. And I think that both the SEC and the CFTC are really spending some time thinking about the space and how they want to approach it, both from a collaboration side, right, from FinHub and Lab CFTC, but also for projects that, at least to start, are sort of the low-hanging fruit projects like they did with the ICOs, pure fraud, clear, flagrant violations of the rules and the regs. So I think there is going to be a tail off of this for sure, both private litigation and regulatory enforcement action.
Cool. I'm sorry we didn't get to answer everyone's questions, but the folks on here these are some of the finest lawyers in the space. I think, generally speaking, folks are happy to hear from you. Unless someone says otherwise, feel free to reach out to any one of us via email, Twitter, LinkedIn, Pigeon, whatever. A lot of fun, guys. Thanks so much. Hopefully we can do it again.
Thanks so much, Stephen.
Thanks.
Thank you for hosting.
Thank you.
Thanks.